y bienvenido a mi canal. Yo me llamo Sirey. Soy una abogada afro-latina licenciada practicando la ley criminal, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a hablar de Wade Wilson. Si quieren más video en español, nada más dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latina criminal attorney who, much like the rest of you, has a severe fascination with true crime cases. Listen, guys, much like the Mackenzie Shrella video that we discussed or we talked about, or the case that we talked about on this channel, this is another case that I feel like has reemerged, quite frankly, from the depths of demonic hell. I don't want to say it like that, you guys, but it's crazy. Anyways, this is the case of Wade Wilson. Okay, you guys. So I know that Wade Wilson was recently featured on a show or a series on Netflix called My Worst Ex or The Worst Ex or what have you, right? And I know that there were multiple people in that series or in that episode, his specific episode, talking about their experiences with him. This is not to discount any of their experiences at all in the slightest, but we're just going to talk about the criminal case itself and my opinions on it, what's happening recently, and the like. Okay, so for those of you guys who don't know, on October 7th of 2019, Wade Wilson decided, quite frankly, that he was going to kill two women for the purposes of his own self-aggrandizement, let's say. He is said to have allegedly been heavily hooked to narcotics and other substances. And because of that, he just killed two random, unsuspecting, innocent women for literally no reason. The two women that Wade killed, and I'm not saying allegedly anymore because he's already been convicted and sentenced of these crimes, were a 35-year-old woman by the name of Christine Melton and a 43-year-old woman by the name of Diane Ruiz. In a super, super, super oversimplified version, basically what happened is this. Wade was able to convince Christine to go home with him. They met at a local bar. They went back to her home. As she slept, he strangled her to death. Literally hours after killing Christine, Wade was able to lure a poor and unsuspecting Diane as she was walking to work because she just wanted to be a good person and volunteered her time to try to give him directions that he asked for, and he strangled her too. After he strangled her, he decided to run her over with the vehicle that he was driving. And I think, to quote him, based on what he said to his father, to the point where she was flat or smashed like spaghetti. Just absolutely catastrophic, horrific, vile, disgusting, disgusting things. Ultimately, as I said previously, he's already been convicted of these heinous and despicable crimes. Okay. It's also my understanding that there's an appeal that's currently pending. I got my hands on the initial appellant brief, and I figured it might be interesting if we go through it together. So let's go ahead and get started. Statement of the case and course of proceedings. Wade Stephen Wilson, hereinafter Appellant Wilson, was charged in Lee County with 2 counts of first-degree murder, counts 1 and 4, 1 count of grand theft of a motor vehicle, count 2, 1 count of battery, count 3, 1 count of burglary, count 5, and 1 count of petty theft or petite theft, count 6. The offenses occurred on October 7th, 2019. The victims of the 2 murder offenses were Christine Melton and Diane Ruiz. At trial, Appellant Wilson was represented by Lee Hollander, Esquire, and Kevin Shirley, Esquire. The state was represented by Assistant State's Attorneys Sarah Miller and Andreas Gardiner. The Honorable Nicholas Thompson presided over the trial. The trial began on June 3rd, 2024 and concluded on June 12th, 2024. At the conclusion of the guilt phase, the jury found Appellant Wilson guilty as charged for all counts. The penalty phase began on June 24th of 2024 and concluded the following day. At the conclusion of the penalty phase, the jury recommended the death penalty. For the murder count relating to Miss Melton, the jury 1 unanimously found that Appellant Wilson was previously convicted of a felony and under sentence of imprisonment or placed on a community control or felony probation. 2 unanimously found that Appellant Wilson was previously convicted of another capital felony or a felony involving the use or threat of violence to the person. And 3 unanimously found that the murder was especially heinous, atrocious, or cruel, and that the jury found by a vote of 9-3 that Appellant Wilson should be sentenced to death. For the murder count relating to Miss Ruiz, the jury 1 unanimously found that Appellant Wilson was previously convicted of a felony and under sentence of imprisonment or placed on community control or on felony probation. 2 unanimously found that Appellant Wilson was previously convicted of another capital felony or of a felony involving the use or threat of violence to the person. 3 unanimously found that the murder was especially heinous, atrocious, or cruel. 4 unanimously found that the murder was committed in a cold, calculated, and premeditated manner without any pretense or moral or legal justification, and the jury found by a vote of 10-2 that Appellant Wilson should be sentenced to death. The Spencer sentencing hearing was held on August 27th of 2024. The trial court sentenced Appellant Wilson to death for both murder counts, and the trial court rendered a detailed sentencing order that weighed the relevant aggravating and mitigating circumstances. The state's case in chief, Joshua Lukich. Mr. Lukich stated that one of his friends previously introduced him to Appellant Wilson, and he said that on October 7, 2019, Appellant Wilson approached him at his business on Hancock Bridge Parkway. Mr. Lukich testified that Appellant Wilson was there trying to get a plane ticket or a bus ticket or whatever he could from me to leave town. And he said that Appellant Wilson was wearing sweatpants only, no shoes, no shirt, and he was bloody and he was missing a couple of teeth. Mr. Lukich stated that Appellant Wilson's demeanor was frantic and in a rush to leave as quickly as he could because he had just done something horrific and killed people. And he rolled up someone in a carpet or bedding or whatever it was. Mr. Lukich testified that he told Appellant Wilson that he needed to leave and pick up an employee. And he said that once he separated from Appellant Wilson, he called 911. During Mr. Lukich's testimony, the state played the recording of the 911 call to the jury. Christopher Anzalone. Officer Anzalone with the Cape Coral Police Department stated that he responded to the 911 call that was made by Joshua Lukich. Officer Anzalone testified that when he arrived to Mr. Lukich's business, he came into contact with Mr. Lukich and he subsequently searched the premises for Appellant Wilson, but he said he was unable to locate Appellant Wilson. However, Officer Anzalone stated that he was able to locate the vehicle that Appellant Wilson had been driving, a black Nissan Versa, and he said that 1, the vehicle appeared to have blood on it. 2, the vehicle had front end damage. And 3, a record search established that the vehicle was registered to Christine Melton. Officer Anzalone testified that law enforcement officials subsequently attempted to contact Ms. Melton. Patricia Bell. Detective Bell with the Cape Coral Police Department testified that as part of her investigation in this case, she learned that Christine Melton was out with Stephanie Johnson on the evening of October 6th, 2019. Stephanie Johnson. Miss Johnson, a friend of Christine Melton, testified that on the evening of Sunday, October 6, 2019, she went to Miss Melton's house and the two subsequently went to the Buddha Bar in an Uber. Miss Johnson stated that while they were at the bar, they were approached by Appellant Wilson, who referred to himself as Junior. Miss Johnson testified that she and Miss Melton then socialized with Appellant Wilson and a man named Jason Shepard, and she said that Miss Melton and Appellant Wilson seemed to be attracted to each other. Miss Johnson testified that when the bar closed, the four got into a vehicle that she believed belonged to Appellant Wilson, a Dodge Hellcat, and Mr. Shepard drove them to his house. Miss Johnson stated that when the four arrived at Mr. Shepard's house, they went to Mr. Shepard's bedroom, and she said that Miss Melton and Appellant Wilson engaged in consensual sex. Miss Johnson testified that she, Miss Melton, and Appellant Wilson then left Mr. Shepard's house and took an Uber to Miss Melton's house, and they left the Dodge Hellcat near Mr. Shepard's house. Miss Johnson stated that after the three arrived at Miss Melton's house, the three went inside, and she said that at approximately 6 a.m., she left Miss Melton's house because she had to go home in order to get ready for work. Miss Johnson testified that later that day, i.e. Monday, October 7th, 2019, she attempted to text and call Miss Melton, but she said that Miss Melton did not respond. Miss Johnson stated that later that afternoon, she received a phone call from a police detective, and she said that based on that call, she went to Miss Melton's house, and she indicated that when she arrived at Miss Melton's house, law enforcement officials were present and they had placed caution tape around the entrance of the house. On cross-examination, Miss Johnson stated that during the time she was with Miss Melton, Appellant Wilson, and Mr. Shepard, she observed all three of them using cocaine, smoking marijuana, and drinking marijuana. Let's stop right there. As you guys read it on the screen, it legit says drinking marijuana. I know, because a lot of times that I'm reading through these motions and briefs and stuff, sometimes I will misstate a word, but this is not one I misstated. It literally says drinking marijuana. I'm gonna put it right here. It says drinking marijuana. Is that possible? I'm not even trying to be funny. Is that possible? Or was just a mistake? Go ahead and let me know down below. But anyways, let's carry on. Jason Shepard. Mr. Shepard stated that on the evening of October 6, 2019, he was at the Buddha Bar and he met Stephanie Johnson, Christine Melton, and Appellant Wilson, who referred to himself as Junior. Mr. Shepard testified that when the bar closed, the four went back to his house. Mr. Shepard stated that when the four arrived at his house, Miss Melton and Appellant Wilson went into his bedroom and engaged in consensual sex, and he said that he and Miss Johnson went to the backyard and talked. Mr. Shepard testified that between 3 a.m. and 4 a.m., the other three left his house. Charles Caruso. Sergeant Caruso with the Cape Coral Police Department testified that he and other law enforcement officials responded to Christine Melton's house on October 7th, 2019, and he said that after they entered the house, they discovered Miss Melton's dead body under a large bundle of sheets and clothes. Miss Potts, a forensic technician with the Cape Coral Police Department, testified that she responded to Christine Melton's house on October 7, 2019, and she said that when she arrived at the house, she took photographs of the scene and collected evidence, and during Miss Potts' testimony, the photographs and evidence were shown to the jury. Miss Potts stated that after processing Miss Melton's house, she obtained buccal swabs from Appellant Wilson. Noelia Hernandez. Dr. Hernandez, a medical examiner, stated that she conducted the autopsy on Christine Melton. Dr. Hernandez gave the following conclusion regarding Miss Melton's cause of death. Based on what I was explaining earlier in the neck, how she had hemorrhage extending from the superficial muscles all the way to the deep muscles, as well as the bruises on the outside of her neck, and also she had petechiae on one of her eyelids and petechiae on her scalp. It's all on her autopsy findings taken together are consistent with death by asphyxia due to compression of the neck. I'm going to stop right there and just go back to something that I previously reminded you guys about, or something that I previously told you guys about in a past video. Remember? So you know how I told you guys that a lot of, attorneys, legal professionals, whatever, will describe cause and manner of death typically as one joint statement, but it's never that. It's two different things. Right here, Dr. Hernandez is just saying the cause of death is asphyxia, so strangulation, right? Did you guys see me hit the microphone? But it's strangulation, right? And the manner of death is homicide. I just wanted to use this as a teaching moment to kind of explain some of the things that I've previously explained to you guys, so we're all on the same page. Let's go ahead and carry on. Dawn Griffin. Miss Griffin stated that on October of 2019, she was working at Benson and Associates, an interior design company. Miss Griffin testified that on October 7th of 2019, she arrived at work at 6:30 a.m. and she said that at approximately 7:30 a.m., she observed a man who was not wearing a shirt and who had several tattoos pass close by the door of her office building. Miss Griffin stated that she then heard a voice, and she said that when she looked outside, she could see the man and another person with blonde hair struggling with each other. Miss Griffin testified that after observing the struggle, she called 911. Okay, you guys, I'm going to stop summarizing all the testimony because in reviewing this brief, it's like numerous pages of testimony being summarized, okay? So I'm not going to do that. We're going to get right now into the argument because that's the whole purpose of this brief. And if I didn't already say this, I don't think I did on this video, but this brief is 108 pages, okay? So bear with me, but let's go ahead and get into the arguments right now. Summary of the argument. Appellant Wilson raises 6 claims on appeal. First, the application of the 2023 version of Section 921.141 Florida statutes, which eliminated the jury unanimity requirement to Appellant Wilson's offenses, which occurred 4 years earlier in 2019, violates the ex post facto clauses of the United States and Florida constitutions, as well as Florida statutory law. Okay, you guys, before we get any further, let me just stop right here and explain this to you, okay? Basically, what they're saying is because the court applied a 2023 statute to offenses that Wade committed in 2019, and specifically the statute eliminated the unanimity requirement. And if we'll remember, in the death penalty phase, there was a majority of the jurors who voted that he should be sentenced to death, it wasn't like every single juror, right? It was like 10-2, 9-2, or whatever, 9-3, sorry, whatever, right? So basically what they're saying is that this violates the ex post facto clause, which in essence states that it was a violation to have used this specific law because this was not the law in effect when the crimes were committed. So this 2023 statute was not in effect when the crimes were committed in 2019. Do you guys understand? Does that make sense? So yeah, that's the crux of argument number 1. I'm sure they'll go into it even further, but let's go ahead and carry on and see what else they argue. Second, this court's holding in State v. Poole that unanimity was not constitutionally required in capital sentencing except for the finding of one or more aggravating factors should be revised in light of the Supreme Court's affirmation in Ramos v. Louisiana of the right to a unanimous verdict as inherent in the right to a jury trial. Okay, let's stop right here and I'll explain this to you. Basically, what they're saying in the second argument is that this court is wrong. That's what they're trying to say, that the court is wrong. And the court is saying, or according to them, or their interpretation is that the court is saying that unanimity is required unless there's a finding of one or more aggravators. What they're saying is, look, judge, or look, court, there is another case out of Louisiana that says that unanimity in the sentencing phase is also required, much like unanimity at the jury trial, right? So that's what they're arguing there. Third, Florida's capital sentencing scheme does not satisfy Eighth Amendment standards because of the combined effect of the recent elimination of the unanimity requirement, the elimination of proportional review, and the increase over time of the number and scope of aggravating factors. The current system does not adequately channel the sentencer's discretion and does not contain sufficient safeguards against arbitrary and inconsistent capital sentencing. Okay, you guys, let's stop right here and explain this to you. So basically, the provision of the Eighth Amendment that's most important for this argument here is the provision against cruel and unusual punishment, right? And what they're saying here is, Judge, the elimination of the unanimity requirement and all of the arbitrary different ways by which someone can be sentenced to death doesn't help protect a defendant's right against cruel and unusual punishment. Let's carry on. Finally, in Claim 4, Appellant Wilson asserts that Section 921.1416H, Florida statutes, the heinous, atrocious, or cruel aggravator is unconstitutional. In Claim 5, he asserts that Section 921.141, Florida statutes, is unconstitutional. And in Claim 6, he asserts that Section 921.1418, Florida statutes, is unconstitutional. Okay, you guys, I feel like this last argument is kind of self-explanatory, but basically what they're saying is all this stuff, because I'm not going to cuss in this video, I promise, is unconstitutional. And because of that, we need to revisit it, basically, right? So yeah, let's continue on just a little bit. I'm not going to read the entirety of this brief, but let's just continue on just a little bit further, okay? Conclusion. The appropriate remedy for all claims is reversal of the death sentences that were imposed in this case. Okay, let's stop right here. So I did say let's carry on just a little bit further, but I didn't know how technically I was going to take it until I got to the conclusion section. And I was like, literally a sentence, right? Anyways, so basically, let's kind of separate this brief from some of the others that we've read, right? Some of the other appeals briefs that we've read. And in separation or distinction, we can note that here they're not arguing for reversal of the convictions, but instead they're arguing for reversal of the death sentence, right? So basically what they're saying is, we're not going to dispute the fact that he did it. There was enough evidence, there were confessions, there were this, that, and the third, there's enough people, there's enough eyewitnesses, all of this happened. But does he really need to be sentenced to death? Basically is what they're saying, right? I know that there were additional motions filed in this case, specifically as it relates to the appeal. I believe the prosecution filed their reply. There might have been additional motions that were filed on behalf of Wade. And you guys are going to have to wait until subsequent videos to hear my interpretation and my opinions on those motions. Before I let you go, I wonder if it looks weird that I'm pointing like this. But before I let you go, okay, you guys, as I say to you all the time, I really, 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 really enjoy making these videos. I do. I really like talking to you guys. I like explaining these things. I like going through the statutes, briefs, cases, whatever. I enjoy talking to you. If you enjoyed listening to me yap, Could you please potentially like, comment, share, and subscribe? Could you please? Could you please? Could you please? It really helps me out so much. As always, thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.